What is evidence presentation in confidential arbitration? Imagine trying to solve a puzzle where some pieces are hidden and others are kept secret. That's similar to what happens during evidence presentation in confidential arbitration. It's a process where parties show their proof and support their claims in a private setting, away from public view. This process is different from court trials, which are open to everyone. In arbitration, the goal is to keep the details private, especially in industries like sports and entertainment, where privacy matters a lot. In arbitration, parties usually agree to resolve their disputes with the help of one or more neutral people called arbitrators. These arbitrators listen to both sides and decide who is right. When it comes to evidence, parties submit documents like contracts, emails, financial records, or expert reports to support their case. They might also call witnesses to testify about what they saw or know. All of this happens behind closed doors, which helps protect sensitive information. Handling evidence in confidential arbitration involves some legal rules. For example, parties need to carefully manage sensitive documents. They often sign confidentiality agreements to make sure that what they share stays private. If a party accidentally reveals privileged documents, they might need a court order to recover or keep those documents secret. Witnesses are also asked to sign confidentiality agreements to prevent them from sharing what they hear during the process. While the arbitration process itself remains private, the final decision or arbitration award might not always stay secret. In many places, the award must be filed with a court to be enforced. This can sometimes lead to public disclosure unless the parties agree to keep it confidential. In sports, for instance, the Court of Arbitration for Sport handles many disputes and keeps them private unless the parties decide otherwise. In today's digital world, online arbitration has become more common. This makes confidentiality trickier because digital platforms need to be secure. Parties must choose platforms that protect their information and make sure everyone understands their confidentiality obligations. In sports and entertainment, confidentiality agreements are often detailed and specific. They spell out exactly what information is secret, who can see it, and what happens if someone breaks the rules. In summary, presenting evidence in confidential arbitration is about carefully managing sensitive information, following legal rules, and respecting confidentiality agreements. This process helps industries like sports and entertainment resolve disputes privately, protecting reputations and sensitive data.